Hi everyone, and welcome to another edition of Law Talk. We're here at Cefalo and Associates, Wyoming Avenue, 309 Wyoming Avenue, West Pittston, and the number here, folks, 655-5555, and of course it's on the screen. Remember what their slogan is? We're the people's law firm, and what, Mike?
We like it that way.
That is such a great slogan. Today, folks, we're going to learn about workman's compensation and when you get hurt. And attorney George Oschal is here right after we talk to Mike. Well, first of all, Mike, let me tell you that we've had some great comments on the first show, and you brought a lot of interesting points across. The reason I wanted to have you on the show before we bring George on, I got an interesting phone call from someone in Beaver Meadows, Pennsylvania. And the person said to me, Sam, I watched the show with Attorney Cefalo, and she says, she said, when I pick up the paper, I see a picture of a lawyer, and it's beautiful things about the lawyer, what they've accomplished. Then I turn a page, and I see another picture of a lawyer, and I see what they've accomplished. Then I turn a page, I see another picture of a lawyer, super lawyers or whatever. And she said, I'm sure they're all wonderful lawyers. She said, and I go to Yellow Pages, and I see other lawyers. How do I really know, okay, if I really need an attorney, who do I go to?
Well, that's an interesting question. I thought about that myself, saying if I needed a lawyer, who would I go to? And one of the reasons, or one of the things I've come up with, is if I needed a lawyer, I'd want this firm to represent me. We've been here a long time. I've tried too many jury trials to count. I've been there. We have a lot of experienced people, and George Oschal, you're going to hear a lot about him. He's been here 31 years. And he probably forgot more about workman's comp than I know. And we kind of have divisions, and we have a medical malpractice section, and we have a motorcycle section, and we have a workman's compensation section. They're special departments. A lot of people talk a lot of things about a lawyer, and some people just make a decision, spur of the moment. I know John Doe, I know Harry Smith, my cousin's a lawyer, my nephew's a lawyer, and they go to him and they really don't understand. The other thing is, if you had a problem with your heart, you'd want to go to a specialist. You'd want to go to somebody who really knows what's going on. You don't want to go to a general practitioner if that's the problem you have. So that's maybe a convoluted answer, but that's the best answer I can give.
Yeah, and I can understand that, because as the show Law Talk, when we started the show, is to inform people about different things, like you did in the previous show, telling them what mistakes people make, okay? Now, the firm itself, you said how many lawyers you have here?
We have 9 lawyers. I always say too many, but there are 9 lawyers here.
Right. And you specialize in?
What we do, what we specialize in is we do personal injury, in a sense. And that's workman's comp, that's Social Security, disability, and that's injury cases. In addition to that, we do, or I do because of my background, we do complex criminal law. We call it a Ponzi scheme now. It's not, we call it Mitty Madoff. It's not Madoff with billions of dollars, but there's several millions involved in it. And that's what we do. We're a trial firm. We're not people that just go around and do other things, such as we don't do real estate, we don't do estates, we don't do domestic relations, we don't do support, we don't do visitation, we don't do any of that stuff. We basically do personal injury work.
Okay, George is coming up right after the break, and he's going to be talking about workman's compensation, and you said he's been with you for 31 years.
Yep.
Yeah. What can people expect to hear when George comes on about workman's compensation?
Let me tell you, he knows every single problem that arises in a workman's compensation case. Every single problem. There isn't any that he hasn't encountered. I did workman's comp for a long time. I don't kind of do it anymore, although I know some of the intricacies of it. But when I have a problem, I call George. I say, hey, George, what about so-and-so? What about this? What about that? What should he do? Some client calls me up. He's very, very, very knowledgeable. I mean, he just knows what's going on, and he's been around a long time.
All right, well, folks, thanks, Mike, for coming on. Folks, remember, we're here at Cefalo and Associates, excuse me, West Pittston. The phone number is on the screen. We come back. There are a lot of things about you commonly asked questions about workman's compensation, and we're going to have an expert tell us about them right after this break. Welcome back to Law Talk, folks, brought to you by Cefalo and Associates here at 309 Wyoming Avenue, West Pittston. Phone number is on the screen. They are the people's law firm, and as they say, we like it that way. Now joining us is attorney George Oschal. And George is certainly, as Mike told you, attorney Cefalo said, he's been with the firm for 30-some years. And so before I even, first of all, thanks for coming on the show.
You're very welcome.
George, why did you become a lawyer?
Well, it's a kind of a long story. I could attribute it really to two people primarily. First, my dad. My dad was a letter carrier, and he was a very bright individual, and had an opportunity to go to what was then St. Thomas Aquinas College. That was the forerunner of the University of Scranton, and decided that he didn't like school, so he went out and worked, and so he never went to college, but he became a letter carrier. Positive influence in my life, and so as I was going through high school, I said to myself, you know, I don't really like school either. I was a pretty good student also. My dad said, well, George, I don't want you to make the same mistake that I did. I said, well, what do you mean? He said, I had it, and I never knew this, but he told me, he said, I had an opportunity to go to college, and I didn't take it, and he said, I don't want you to make the same mistake I did. I want you to be end up better than I did, which is the wish of every parent. So I started to think about, what do I want to do? What do I want to go? Where do I want to go? And I had a teacher in high school, a fellow by the name of John Pepe, who taught a course called POD, which is abbreviated for Problems of Democracy. So I started to talk to him about, you know, what should I do? He said, well, George, he said, why don't you, he said, you seem to be pretty bright. He said, you talk well. Why don't you think about becoming a lawyer? And I had never thought about that. I said, well, I said, that sounds like maybe something that I might want to do. But I said, don't I have to, that means that I have to go to school another 3 years after college. He said, well, yes, it does. He said, but he said, you should also make plans in the event that, you know, after 4 years of college, either you don't get in or you change your mind. So you should take something that is going to be beneficial to you. So he recommended that I become a CPA and a lawyer. So I went to college, and I graduated in 1979 from Wilkes, and I became I was an accounting major. Never used my accounting degree. Went to the University of Dayton Law School and graduated there in 1982. Became a lawyer, and in 1983 I started here with Mike Cefalo, and I've been here ever since, and very happy with what I do, and very pleased with how it turned out.
Prior to our show, you talked about the Carnegie Award that was, just as briefly, I think that was fabulous.
Well, yes, my maternal grandfather was an Italian immigrant. His name was Amedeo Pencati, and he came to this country when he was 16 years old, and he was a coal miner. And he was a coal miner all of his life, basically, and in 1959, everybody from this area who's old enough to remember the Knox mine disaster, he was involved in that. Make a long story short, he climbed a 60-foot air shaft in the dead of winter, which was almost at a 90-degree angle, and saved, I think he was credited with saving 42 people. They all came out through that same air shaft. Wow. And the Carnegie Commission, of course, before they award a medal, they do an investigation, and they did the investigation, and they said that this fella actually warrants receiving the Carnegie Medal, which is the highest civilian award for bravery that you can get in this country. It's kind of like the civilian equivalent of the Congressional Medal of Honor, wow, which you would have for a service person. Yes. So that's where I come from. My grandfather was a coal miner. My mother's father, my father's father was also a coal miner at some point. Not too many years, but he did work in the coal mines. He became a police officer in Pittston. And my dad, as I said earlier, was a letter carrier. So when Mike talks about the people's law firm, and you know, I have that kind of a background. I come from a blue-collar background, and I'm proud of it.
You fit right in with the firm.
Absolutely.
And for 30-some years, that's fantastic.
Yes.
All right, now, there's this, I think this subject matter today that we're talking about, folks, it's workman's compensation. And there's a lot of questions that people have about workman's compensation. So first of all, if something should happen, how do I cooperate?
Well, that's you know, one of the things that we get all the time is when people get hurt on the job, they don't know necessarily what the procedure is and what they have to do and what are their responsibilities, but they do know that they're hurt, and they know that they're going to need money while they can't work. So they call us up and they say, well, what do I have to do? And one of the things that I tell them is, first of all, unlike what would happen in a car accident case where if the insurance company calls you up and they want to take a statement from you, we generally don't want to do that. In fact, Mike Cefalo talked about that in your first show. Don't give them a statement. But in workers' comp, it's a little bit different. When the insurance carrier calls you up, you really have to tell them what happened. You have to let them know if there are any witnesses. You have to let them know if you've been injured, which doctors you're seeing, because if they don't have that information, it's a virtual certainty that they're going to deny your claim. But I also tell people that before you make that statement or before you talk to the insurance carrier, give us a call because we can kind of help you and we can walk you through the process and kind of prepare you.
So what you're saying, so then if before they give that statement, okay, they should contact you and then you could guide them with what do I have to say.
That's right. Or us or any lawyer that really does workers' compensation. But the point is, you're trying to navigate yourself through, for most people, what is potentially a minefield. So if you don't give the correct information and present it in the right way, they may very well just deny your claim. So it's not worth taking that chance.
Well, so that follows in. Do I have to allow them access to my medical records, including records which predate the accident?
Well, yes, you do, and here's why.
Should it be under the lawyer's guidance?
Yes,
Okay,
yes.
that's what I'm trying to.
What will happen is if, let's say the insurance company does an investigation and you have an incident at work and they send their investigators out and they find out that yes, this person really there was an incident at work and they appear to be hurt. The next step in the process is going to be they want to know if you have been injured and if the injury that you're claiming disables you, in other words, prevents you from working and returning to your normal employment. So if, let's just say, hypothetically, it's a back injury. If you've had a previous back injury, the insurance company is going to want to know that if you're claiming a back injury, that your disability from the incident at work comes from that as opposed to something that may have happened beforehand. So that's one of the reasons why they're going to want to get your previous medical records. But people are concerned about that. They say, well, why do I have to give them access to my medical records? Because it's really none of their business. But sometimes it is. So the answer to that question is yes, you do have to give them access to your previous medical records.
If you just tuned in, folks, this is Law Talk brought to you by Cefalo and Associates. And we're talking to attorney George Oschal, who is an expert or really knows workman's compensation, and we're asking some common questions. Okay, the other question is this. So first of all, if before I even talk to an insurance company, give you a call so you can guide me to do the right thing. Okay, can I sue my employer for pain and suffering?
This is one of the most common questions that we get. It happens this way. Somebody is at work and let's say they work in a plant, manufacturing plant, and let's say that there's a dangerous condition that exists at the plant, like maybe there's some unrepaired steps or there's a hole in the floor or something. And somebody, while they're at work, on the job, they fall on the floor, in the hole, and they say, this accident would never have happened if they had only patched it up or if they had only fixed this and not allowed it to exist for a long period of time. So I want to sue them for pain and suffering. Well, the problem is, under Pennsylvania law, you can't do that. Pennsylvania law says that if you get hurt on the job, you're pretty much entitled to only two things, which is A, your wage loss benefits, and B, any medical expenses that you incur as a result of the injury. Now they say, well, why can't I sue for pain and suffering? And the answer to that is that there's two sides of that coin. If a person gets hurt on the job, and let's say they get hurt because of their own negligence. Let's say somebody is walking in the same plant, but they trip over their own 2 feet, or their own clumsiness causes an injury. Well, you know what? Because it happened on the job, they're still eligible to receive their workers' comp benefits, and they're also eligible to get their medical expenses paid. So in one sense, Sam, the law gives you something on the one hand, which is the ability to collect workers' comp benefits and your medical expenses, even if the accident is your own fault, but it takes away your right to sue them like you would, let's say, for pain and suffering if it was a car accident or a slip and fall someplace else. Takes away your right to sue your employer for pain and suffering, but either way, you can collect your you can get your medical expenses paid and collect your workers' comp benefits. That's why they call it a no-fault system.
Can I sue a third party for pain and suffering?
That you can do. So there are many instances where people are injured while they are actually working. The term is while they are in the scope of their employment, and they get hurt due to the negligence of somebody else, somebody other than their employer. For instance, you have a traveling salesman, let's say. He's out on the road and he's making calls, and he gets involved in a car accident. Somebody runs a red light and they smash into the salesman, and now the salesman is injured. So the salesman calls me up and he says, well, I got into a car accident, and what can I do? I said, well, first question I ask is, were you on the job? And he says, because he's telling me that he's a traveling salesman. If he's on the job, yes, he can file his workers' comp claim. He can still get his wages and his medical expenses paid through workers' comp. But in addition to that, now because there's somebody other than his employer who was responsible for the accident, he can also bring a claim against the person who caused the accident. In other words, the person who ran the red light. He can bring a claim against that party for his pain and suffering. So the answer to that question, Sam, is yes.
I'm talking to Attorney George Oschal, folks, from the Cefalo and Associates law firm, the people's law firm, and as they say, they like it that way. When we come back, here's another question I'm asking. If my claim is approved, what am I entitled to under the law, and once on comp, do I still have to cooperate, and many more interesting questions that you want to know. Stay with us. Back to Law Talk, folks. Remember, 24/7, you can watch any show that we produce, particularly all these Law Talk shows brought to you by Cefalo and Associates. The website, ssptv.com. My email, folks, sam@ssptv.com. And if you have any questions for any one of the lawyers here at Cefalo and Associates, like we had previously, please email me, and I'll certainly bring them to their attention, and we can address maybe not all of them, but some of the ones that are pertinent. I'm talking to Attorney George Oschal, folks, from the Cefalo Associates, and we're talking about commonly asked questions on workman's compensation cases. Now, if my claim is approved, okay, what am I entitled to under the law?
Okay. We kind of touched on that a little bit before, Sam, but I'm going to talk in a little bit more detail. First, they're entitled to what they call indemnity benefits, and these are a substitute for your wage loss benefits. Basically, what the law does and what the compensation insurance carriers do is they calculate your average weekly wage. In other words, they go and there's a formula, it's a sophisticated formula, and I'm not going to go into the specifics of it here for purposes of this show, but they come up with your average weekly wage and they pay you 2/3 of that in terms of compensation. And they will continue to pay you that for as long as you are disabled and unable to return to your normal job or your customary employment. So that's part one. And then part two is, as I said also earlier, they are obligated to pay your medical expenses, but that is not always as easy and as simple as it sounds. They are only obligated to pay your medical expenses that you can show arose from the work injury. In other words, if it's related to the work injury, they have an obligation under the workers' comp statute to pay for those. If they have a question and they think that there are some medical expenses that may really not be related or maybe due to a previous condition or another medical condition, they do not have to pay for those. And that oftentimes results in litigation happening because some folks have pre-existing conditions, like if they have a neck problem. Let's say they have a neck injury at work, but they already have arthritis in their neck. Things can happen where the carrier is not necessarily convinced that this is treatment for the work injury. They may think that it's because of the pre-existing condition. So there could be a problem with that. But in general, you're looking at your indemnity benefits and your medical expenses.
One of the things, folks, that you have to understand is that when you get injured, I'm not to be a lawyer, but sometimes the injury can enhance the condition that you have.
That's correct.
So therefore, if you have a concern, well, maybe you're taking medication for et cetera, but this accident actually enhanced it, and now we have, and that's where we need Attorney George Oschal to give you information. Now, once on comp, okay, do I still have to cooperate?
And the answer to that question is yes. You do have to continue to cooperate, because one of the things that we see happening is if you've got a major injury, which is going to result in a disability for maybe 6 months to a year, or maybe even anticipating the long term. a lot of times what insurance carriers will do, and they have every right to do this under the law, they will refer the injured worker to what's called a case manager. Case manager is like a nurse, somebody that will go to the doctor's appointments with the injured worker and to kind of monitor medically what's happening, and then they will report back to the insurance company and basically let them know what's happening. Normally, what happens also is once or twice a year, they have the right to ask you to submit to an examination by a doctor of their choice. It's called an independent medical examination, and again, you've got to cooperate, you've got to do that, because if you decide that you don't want to go to the medical examination, you are potentially putting your benefits in jeopardy. So you certainly don't want to do that. But again, if you've got a lawyer who's representing you through this process, he can kind of guide you through the do's and the don'ts of the independent medical examination rather than just kind of going in there on your own. Another item that arises is they sometimes hire what they call vocational counselors. These are people who are specialists in jobs. We talked about this a little bit earlier. If you remember, we talked about the fellow who had a back injury, was a construction worker, and let's say that his doctor has released him to go back to light duty work, but the doctor or the employer has no light duty work. So what the comp carrier may do at that point is they may say, okay, we're going to refer you to a vocational counselor who's going to go out there and they're going to look and see if there are any jobs out there that are available to you within your physical restrictions, which would be light duty in the example that I gave, because if there are, then they try to get you back to work, because if they can get the person back to work and earn the same amount of money that they were earning at the time of the injury, then they no longer have to pay workers' compensation benefits. And of course, ideally, that's what they would like to do. Or if they return to work, but they return to work at a lesser wage, the injured worker would receive what's called a partial disability benefit, meaning that they would earn the money that they're earning from the new job, but they would also get a partial workers' compensation benefit so that they're roughly earning about the same amount of money that they were earning when they were on full comp. So it's a kind of a complicated thing, but again, this is why you need a lawyer, because when they call you up and they say, well, you know, your doctor has released you to light duty, and we get these questions all the time from people who are on CompSam. They say, well, do I have to take this job? Why do I have to go and do a job that I don't want to do, or maybe I don't even think I can do? The situation is such that if it can be shown that there's work available that you can do physically and you're vocationally able to handle it, meaning you can read and write and do whatever is required of the job, unfortunately, you might have to go back and at least attempt that job. So these are questions that people ask us all the time. But the bottom line is that, yes, you do have to continue to cooperate. And then probably the last reason that what comes to mind is we get calls all the time about folks who are on comp and they have prescriptions. Let's say people are in pain, they have pain medication. A lot of times they will go to their doctor, the doctor will prescribe the medication, and the comp carrier, for whatever reason, decides that they don't want to pay for it. So if we're on the case and we're handling it, we get in touch with the comp carrier and we say, hey, why aren't you paying this bill? It may be a simple thing where they would say to us, well, you know, we need some sort of verification from the doctor that this pain medication is A, needed, and B, it's related to the accident. Because if they're not just going to write, they're just not going to blindly pay for medication without having proper verification from the doctor that it's needed. So we can help you with that process as well, or any lawyer that does workers' comp. So the bottom line is, Sam, yes, you do have to continue to cooperate.
We got about 2 minutes left, and there's so much more I want to ask you. So first of all, if my check is always late, what can I do?
Well, if the check is late, this is something that happens, quite frequently. It could be something as simple as a glitch in the computer. It could be it just could be an oversight. And other times, it may not be. So it's a good thing to have a lawyer that you can call to say, hey, you know what, I'm not getting my checks on a regular basis. And what we try to do is we do everything we can to try to assist our clients to make sure that they get their checks paid on time. And it's usually either a weekly check or a bi-weekly check, but you know, we do everything we can to put the pressure on the carrier to make sure that our clients get paid.
Now, I know this is going to take you more than 2 minutes, but describe the litigation process. You got 2 minutes to do that.
Well, okay, I'll try to do the best I can.
Yeah.
Litigation process is what happens when you have a dispute. It could be at different stages of the proceeding. It could be right out of the box where the comp carrier denies the claim. They do their investigation and they say, we don't think you had a work injury. It's necessary at that point, call a lawyer, because what happens then is you actually end up in a courtroom in front of a workers' compensation judge, and you have to litigate the case. And I tell people all the time, listen, if you're going to have heart surgery, you wouldn't go in and try to operate on your own heart. You wouldn't try to pull your own tooth. Maybe some people do. If you have that kind of a problem, you should definitely get yourself a lawyer that's been there, done that, and knows the process. But the process could be a long process depending on the complexity of the litigation. But that's one example of the litigation process, is if the claim is denied. The other aspect of that is when you're already on workers' compensation and the comp carrier thinks that you can return to work, and you don't think that you can return to work, and they want you to go back and you don't go back. So now the comp carrier files a claim to either terminate or suspend your benefits. And again, it's the same process in front of the same judge. But again, you do need to have a lawyer represent your interests, because you're going to have to submit medical evidence, usually in the form of a deposition. And it's a kind of a complicated, it's like a mini court case is what it is.
You know, it boils down to this, George, talking to attorney George Oschal, folks, of the Cefalo Associates, who is, yeah, as you can see, very, very knowledgeable in workman's compensation. It's very simple. To me, God forbid someone gets hurt, the first thing I would do is call you and say, look, I was hurt at work, before someone called. So you could give me, because there's sometimes a lot of people are honest, they don't want to get hurt. But however, they get hurt, they need compensation. Well, they're trying to be nice, but what happens, it bites them in the rear.
Sometimes that happens.
And so you don't want that to happen. So folks, if something should happen, you have a guy for 30-some years been doing this, as Mike said, the Cefalo said, they got the best here at Cefalo and Associates. So George, thanks for coming on the show.
Well, thank you very much, Sam. It was my pleasure to be here.
Pleasure meeting you. 31 years you put up with Mike. God bless you. He's a great guy. He really is. You're watching Law Talk, folks. We're here at Cefalo and Associates, the people's law firm, and they like it that way, as you heard from attorney Oschal. And the phone number is 570-655-5555, plus the 800 numbers up there. Don't forget, go to their website, and you can watch this show anytime, 24/7 on ssptv.com. We'll see you next time.